now is I want to introduce Ms. Allison Hertz from our Palm Beach Gardens office. She is one of the few board certified specialists in condominium and plan development law. So we're in for a treat today. Allison, please take it away.
Thank you, Jeff. Thanks for the introduction. I'm happy to be here this morning. We have some nice weather in my area. I hope everyone else does too. And we're here to talk about condominium specific budget and reserve issues. Again, I'm Allison Hertz from our Palm Beach Gardens office. If for those of you who don't know me, I am corporate counsel to condo and HOA associations. That's what I do all day, every day. Here at Cape Gender Rembam, we primarily represent associations, of course. I do want to mention, because I am very proud of my accomplishment, that I am recently appointed as the co-chair of the Florida Bar's Real Property and Probate Section's Condominium and Plan Development Committee. So the Condominium Committee deals a lot with legislation, reviewing, initiating, working with the division on certain projects. So I am very happy and proud to be now serving as the co-chair of that committee. It brings a lot of information to me and the law firm, which of course we then share with you. So that is a very helpful for everyone out there today. We get to have a lot of the insight that some others may not be able to have due to that position. I could go on and on about myself, and that I don't want to take too much time away from our presentation today. I know everyone is here to hear about budgets and reserves. It is budget season. I know that many of my clients have been gearing up to send out budget meeting notices, preparing their budgets, calling me about reserve issues, asking about the new reserve law. Stemming out of that SB 4D, which I'm sure everyone has heard about. That's the recent Senate bill regarding safety, which includes new reserve requirements, which we will talk about through this presentation. Once again, this is regarding condominium issues, so I just wanted to make this clear that this is specific to condominiums. While if you're a homeowner association board member, you're certainly welcome to continue on with this presentation. But condominium law is much different than HOA law with respect to budget issues. So don't think that don't think it's one size fits all here. So without further ado, we will start in with our program.
And before you do,
go ahead.
Real quick, sorry for the interruption, but now that we have more people signed on, I just want to go over we have a lot of material in a short period of time. I wanted to say this now before Ms. Hertz gets started. So normally we take as many Q&A questions and answers as we could. So you feel free to type in questions in the Q&A at the bottom. But if we have any time, we will take a few. We can't do too many today because of our scheduling for today, but we'll do them at the end. So please do not anticipate many, if any, questions to be answered during. They'll be done at the end if we have time, and I'll answer anything administratively that doesn't require an ESQ after my name. Okay, back to you.
Thank you, Jeff. That is helpful to mention that we do try to provide a lot of detail in these courses. So I would not say this is topical. I would say that this is a pretty detailed course, and therefore we really don't have that much time for questions. So before I take up all the time, let's continue to move forward here. The first section we're going to talk about is regarding budgets generally and operating budgets. One important thing to remember regarding your budget is that your budget must state the estimated common expenses, estimated anticipated expenses on an annual basis, and your actual budget document must disclose the beginning and ending dates of the budget period. I've seen associations actually having trouble with a complaint from the division or submitted to the division because their budget did not contain the year to date, 23 to 24 budget period, or what's known as the fiscal year for your budget. Most oftentimes, a condominium association is going to have a fiscal year that coincides with the calendar year, but sometimes due to certain bylaw provisions or just the will of the membership due to other issues. The bylaws have either been amended to provide that that fiscal year is actually something other than the calendar year. So this is kind of basic, but important to mention that your budget does need to contain that information. Why are we going backwards now? Okay, now getting into more of the meat of the budgeting. What are your budget categories? Well, the statute actually addresses your categories that must be set forth in the operating budget, and this is as applicable. Obviously, your budget is going to be different from association to association. We have, condo associations that have huge projects that are part of mixed use, structures where there's so many different classification of expenses. They have a bunch of staff. They have unique situations that only relate to that specific association. And then, of course, we have, small condos that do not have so many budget categories. So these categories are not necessarily required. They just include, as applicable, administrative expenses, management fees, maintenance. Obviously, maintenance is a big one. And once again, these are anticipated expenses. So you don't have to be perfect here. They're anticipated. Rent for recreational facilities or other commonly used facilities. Sometimes you're under a rec lease or you have to pay the shared facility owner some type of fee related to your use of their property. That should be incorporated into your operating budget. Taxes, if you have to pay any taxes as a property owner that are not incorporated into the tax basis of the unit. Taxes on leased area. Again, these are categories mentioned in the statute to the extent they apply to your association. Security, obviously, limited common expenses, which we'll come back to that in specifically as we go on. That's a specific term of art and it's very important to mention. Some other things I don't have listed on this page include employee salaries. This comes up frequently as to, what level of detail you have to show in your budget concerning employee salaries. Do you have to break out each employee and list them specifically as one line item? Maintenance, management, concierge, whatever you may have at your specific association. But that's really something to be determined by the board and to be set forth either specifically as to each person or lumped together as one item. There is no wrong or right to that, to my knowledge. It just depends how you want to show that in your budget. Obviously, members will get a hold of this budget because you're required to provide it in connection with your budget meeting. So if you do not want to show all of your employee salaries as a specific line item and you want to show them lumped together because that's more beneficial for whatever reason, I believe you can also do that. Pertinent to at this time, we had Hurricane Ian on, and I feel for all of those who have been affected by that. Up in Palm Beach County, we really didn't have that much effect, but I understand many of the people here today might have been highly affected by that and have been thinking about maybe what they can do in the future, and all of us actually, what we can do in the future to help with disaster situations. So that is something that you probably want to think about in terms of budget planning as well, that again, these are annual expenses, not capital expenses in the operating side of the budget, but I believe there probably is some disaster type planning that you can include in this operational side of the budget, and whether that's, new drainage to help with flooding or other types of expenses that you might need vendors for, that is something to think about as well. If you have professional management, this is something where you're definitely going to want to consult them because they've been doing this for a long time. They've consulted with so many different associations for budgeting, and they can help prepare your draft budget and filter through what is appropriate for your association and what is not appropriate. I mean, us at KBR, we don't necessarily propose budgets and numbers And that's left to boards and professionals such as property managers to deal with. And that's what they do. So I would highly recommend that you consult with your property manager, your property management company concerning your budget, what they feel is appropriate for inclusion, what they believe could possibly be removed, what might be more appropriate in your reserve schedule rather than your operating side of the budget. And that is the best way to handle this. Use the help that you have. Don't try to do this alone. You're a board, one member of the board, even the treasurer, should not have to prepare the proposed budget. With that said, if you have a management company helping you with the budget, you want to make sure that they give you the draft proposed budget way in advance. I write into the management contracts that we help prepare for our clients that the draft budget must be provided by management at least 60 to 90 days in advance of the next fiscal year, because you need time to look at that just as a board before you go forward with sending it out as a proposed product to your unit owners. Moving on right now, well, what about insurance expenses, right? I certainly don't think anyone should be budgeting the same amount that you've historically budgeted for insurance premiums. Obviously, we see so many premiums going up, even in the past couple years. Now with Ian, I would suspect that everyone out there will be seeing increases in windstorm, and also we've seen increases in general liability for the past couple of years. Associations frequently tell me that they're going up 20 to 40%, even more. So that is something that you should not under budget for insurance. You should talk to your agent in advance and try to get, once again, the estimated cost. Important to mention, directors and officers insurance. This is not a course about insurance, but as of late, I've heard of several associations that do not have directors and officers insurance. That is not mandated by the Florida Condominium Act, but if you're serving on a board and you are sued in your capacity as a director for something, you want to be able to point to that directors and officers insurance and make a claim and get defense and get coverage for that action. I would be very concerned if I was serving on a board with no directors and officers insurance. So if you're a director or officer out there, please be sure to ask your manager or your fellow board members if you have active coverage. I find that to be highly, highly, highly important. So obviously, sometimes we don't know the exact cost of the premium during our budget season. That will come in at a later time. And just to mention, the Florida Condominium Act does specifically address a contingent special assessment levied in connection with an insurance policy authorized by the statute. So we'll get more to special assessments actually later on in this course, but you budget the insurance costs that you're aware of. And if you are then under the situation where you have a premium that's much more expensive than you anticipated, the statute does imply that you can levy a special assessment for that type of purpose. I think we skipped a couple slides here. So hold on a second. Okay, I think this is about social expenses. I'm having a little bit of a hard time due to my view seeing like the top of the slide. So this was about insurance, bad debt. Okay, going back to that. Bad debt. Bad debt is a budget line item for the operating side of the budget that is appropriate. If you expect to have people not paying their assessments and you historically have seen that, or that is what is anticipated for the year, you are permitted to budget for that bad debt, and that's not that bad of an idea. Going back again, sorry, I keep flipping around here. Social expenses. I think this is important to mention that these are not authorized by the Florida Condominium Act, and the division has historically taken a pretty hard position on this. When associations want to have parties and spend money on these expenses, they believe sometimes that they're not proper common expenses of the association. So if you want to have a significant amount of funds going towards social expenses, I would strongly recommend you talk to your lawyer to determine whether your current governing documents would authorize that, or whether you might specifically need an amendment to provide for some level of authority to charge these social expenses. Everyone would like to go to association events, happy hours. That sounds nice to me, but you don't want to have that owner make a complaint and then have an investigation where your association is found to have spent money unauthorized, and then it makes the board possibly look poor in that regard. All right, now we can get on to the program here. So the budget also must show the assessment basically amount for each type of unit. So we know that sometimes unit owners do not owe the same share of assessment or proportionate share of the common expense. So the budget must show what the assessment would be on a periodic basis for each unit type. So this Florida Condominium Act provides that for condominiums here, you cannot have a periodic payment or installment of more frequently than quarterly. So you can either have a quarterly assessment or a monthly assessment, but you cannot have a yearly assessment or every 6 months for a condominium. For homeowners associations, that's actually okay, but for condominium associations, that's not okay. You probably have seen there in your declaration of condominium, there's always an exhibit page at the end of the declaration, exhibit A, B, C, D, that it must reflect what the allocation is for each type of unit. So if you're under the impression that everyone pays equally, maybe that's really not the case. Maybe everybody pays based on the total square footage or the unit square footage compared to the total square footage of the entire condominium. So that is something critical that you must look to and not just assume that everyone pays equally. In the old days, right, you could have these allocations based on whatever the developer said. You could have one unit paying 20% and everybody else paying, less than that for somewhat of an arbitrary reason, right? Because that the one who paid less was the developer's cousin, something like that. And that's, I'm not making that up. That has happened with these in the old days. But as of 1992, if you're developed as of 1992, the allocation must either be equal or based on the square footage of the unit as compared to the total square footage. So once again, check out those exhibit pages to your declaration to ensure that you are allocating the assessments in a proper manner. Limited common expenses. And just to go back one slide, these allocations are for common expenses that are assessed to everyone. These are across the board assessments, all those categories that we discussed: management, insurance, a lot of your maintenance of common elements. So these are your common expense allocations, but there's something different, and some of you may know this, called a limited common expense. Some of our condominiums here have certain portions or certain components that are limited common elements, such as covered parking spaces, cabana units, storage units, or other types of facilities. These kind of get complicated sometimes. You'll have like a roof deck that could be a limited common element, and sometimes those limited common elements are maintained by the unit owner, and other times they're maintained by the association. The declaration of condominium must specifically address how those limited common elements are maintained. If the declaration does not specifically provide that unit owners maintain those components, then it's the association's responsibility. But you need to look to your declaration of condominium specifically to understand who maintains limited common elements. Common elements have to be maintained by the association per the statute. Limited common elements, once again, can be maintained by owners who use these common elements or by the association as per what is said in your declaration of condominium. So If your declaration of condominium provides that the association is the party responsible for maintaining these limited common elements, it must state how the costs are allocated. If the declaration does not say that those costs are allocated to the user of the limited common element, then they're allocated across the board to everyone. We've had situations where condominiums have these large roof decks where there's about 10 unit owners out of 100 that have these things, and they're very expensive to maintain, right? They need to be ripped up all the time, they have leaks. So if the declaration does not say, does not provide that those expenses can be attributable to the unit owners with the use of the roof deck, for example, then once again, those are going to be assessed to everyone. If the declaration does specifically address that the roof decks, the covered parking spaces, the storage units are going to be the financial responsibility of those who use them, you need to provide a specific, you need to provide for this in your budget. That's what I'm trying to say. That if your covered parking spaces are limited common elements and the limited common element owners pay for that expense, then you have to have a separate portion of the budget that details how that works. That is very important to mention. If you don't, then it becomes a problem later on if somebody doesn't want to pay the expense. So we just talked about common expenses are allocated in the manner provided for in the declaration, either equal basis or some kind of percentage based on the square footage of the unit. Limited common elements, there's that option depending on what your declaration provides for. And that's very, it's kind of strict. You can't change that. That's what your document says. You have to follow your document. You have to follow what the allocations provide for. This is a specific issue regarding bulk cable and communication expenses. If you have a vote of, if your documents set up not non-equal assessment allocations, you're based on those percentages that are not equal, you can take a vote of the unit owners to allocate bulk cable on an equal basis. So this is a special provision of the Florida Condominium Act. So if you're interested in learning more about that, that's something to sort of star this issue and come back to that. It's a very specific issue that we don't really see any option to allocate in a different manner otherwise provided in the Condominium Act. That's something special, I would say, very special. Okay. Just to go over very quickly, because of course we're trying to get through a lot of material here, multi-condominiums are a different animal, I would say. They are an association, one entity that manages and administers multiple different condominiums. Each condominium has their own declaration. So in a multi-condominium, most oftentimes, unless you've consolidated your financials, you have to have a separate budget for each condominium. So you could have, let's just say 20 buildings, and each one is a separate condominium. So each building would have their own condominium budget, and then you would have one overall association budget for the, sort of administrative expenses that are attributable to all of the condominiums. Most oftentimes that's going to be management, legal, some insurance, maybe the directors and officers, but as to maintenance, as to possibly insurance costs, as to items that are specific to that separate condominium, that must be in that separate condominium's budget. There is an opportunity for these type of communities, I will say, to consolidate their financials such that you can have one budget which everybody is responsible for, but these are only for condominiums that are older condominiums. I personally would like to see this as an option for newer multi-condos. If they want to provide for consolidated financials, let them vote and let them do that. But this is something to consider if you believe you're a multi-condominium. You might want to take a look to see if you're budgeting properly. We see a lot of multi-condominium associations that don't realize that they need those separate budgets for each condominium. As opposed to this, there's something known as a phase condominium, where you could have 20 different buildings, but they're all part of the same condominium. So this is kind of technical. You'll have to talk to your lawyer. You probably know if you're one of these, but maybe you don't if you're new to the board or you have new management who doesn't realize that this is the structure. This is a threshold issue for your association if you're in this bucket, I would say. Okay, generally speaking, this comes up all the time. I just want to make it clear that the board is the body that proposes and adopts the budget, and unit owner approval is not necessarily required for budget adoption. I hear of boards saying, well, we got to send the budget out to the owners for approval, and I kind of scratch my head sometimes and I say, I don't understand what you're talking about, because the board proposes the budget and the board has a meeting to adopt the budget. So it's typically going to be a misnomer that the unit owners are approving the budget. The unit owners might have to approve some kind of waiver or reduction of reserve contributions, which we'll talk about shortly, and the reserves are part of the budget, but the board is typically going to be the one proposing and approving the budget. Some bylaws, very few, I've seldom seen this, it's more of an HOA thing, do require unit owner approval for budget adoption, but again, it's just not typical. If you are under the impression that the owners are approving the budget, that might be something to look at in more detail. So you're saying, well, Allison, what if the budget exceeds 115% of last year's budget? The unit owners have to approve it, don't they? Well, that's not necessarily the case. Moving on to the next slide. This is the 115% rule, right? Typically speaking, unless your bylaws are very unique and contain some very restrictive language, the law here is that if a budget exceeds 115% of the prior year's budget, the owners can petition the board to have a new budget, but they do need to have a vote of the membership and they need to actually adopt the new budget. So this is on the owners to petition the board to deal with a budget that exceeds 115%. It is not automatic, I would say. It's not automatic, and it would have to be approved by a majority of a quorum of the owners. In all of my years of practicing condominium law, it's like 16 years now, I've never seen unit owners petition a board to deal with this budget. It just doesn't happen, and this is misconstrued a lot of the time where boards believe that this is an automatic thing. There are a few caveats here. I'll jump to the bottom. If the developer is in control of the board, then it actually is correct. The developer cannot issue a budget that exceeds 115% of the prior year's budget without the approval of the owners. That is an automatic thing, but that's specific to developer control. Additionally, I use this all the time, any determination regarding whether the budget exceeds 115% of the prior year excludes certain things. It excludes reserve contributions, that's not part of the 115%, and it excludes items where the association does not expect to be incurred on a regular or annual basis. As I mentioned early in the presentation, maybe you have some drainage work that you need to get done to prevent flooding, and that has caused your budget to exceed 115% of last year's. Well, that drainage work is not anticipated to be incurred on a regular or annual basis, presumably, so that would be removed from the calculation of the 115%. Okay, now we're getting to reserves, and I feel like a lot of you probably want to know more about this. As we talked, I think early on in the intro, we had the Senate Bill 4D in the special session that was effective May 26th. It came out, 2 days before that, passed by the Senate House, and the governor signed it all within 3 days, I believe, and it provides for new reserve laws. Many of these laws are not triggered yet. While the law is effective May 26, 2022, a lot of these requirements have yet to be triggered. So there's opportunity to deal with some of the issues now, And frankly, there's opportunity for the law to be changed. I would not be that shocked if some of these requirements that are triggered at the end of 2024 are, we'll see a statutory amendment to see them triggered maybe at the end of 2025 or 2026. I don't know how many of you have served on boards forever, but for fire sprinkler retrofitting, we had some requirement that you had to comply by a certain date, then the date was extended, it was extended out again. But on the other hand, these reserve requirements were put in place for safety, and I think it's very difficult for the legislature to go back, I would say, on safety. So we'll get to some of these issues, but first let's talk about our traditional reserve requirements, which are still there. These did not go away. These are applicable to pretty much all associations, caveat, and we'll discuss those caveats later. You have to budget. We talked about operating already, but the other side of your budget is your reserve schedule. Your reserve schedule must include accounts for capital expenditures and deferred maintenance. The items listed in the statute for years and years and years and years and years have been reserves for roof replacement, building painting, and pavement resurfacing, regardless of the cost. And this has been in the statute for years and years, but I think people have frankly ignored it. Any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. Well, $10,000, $10,000 20 years ago obviously is not the same amount now. I find it to be a pretty low number for a reserve requirement, but that is what the statute says. So that would probably include pool resurfacing or tennis court resurfacing and AC mechanical type expenses. That's what we typically see for our reserve expenses. I have the definitions here of capital expenditure and deferred maintenance. You can go back and read those on your own at a later time. But what is new in terms of reserves is our structural integrity reserve study. This is the new requirement that I'm sure you've heard about on other webinars, through your lawyer, through mailers, through the newspaper. It's been all over the place, right? What is it? It means a study to determine what funds are needed for future major repairs and replacements of the common areas based on a visual inspection of the common areas to condominium buildings 3 stories or higher. This reserve study requirement is specifically related to buildings 3 stories or higher. And this is we're talking about a required reserve study. Now, we're not talking about, the funding of reserves right now. We're talking about whether you have to get this type of a study. And this is a buildings 3 stories or higher. What is a story, Allison? Well, it's pretty much a common sense meaning of story. Anything above ground, separated by a slab. I think that's sort of my definition of a story. You can go Google what a story is. You can look in the building code, but generally speaking, that's what a story is. Interestingly, some associations are comprised of multiple buildings. We talked about that. Some associations will be administering multiple buildings. Some might be low rises, 2 stories, some might be 3 stories, some might be 6 stories. So it's a per building analysis. This reserve study has to look at each building. And there's 2 components to the reserve study. There's the visual inspection, and then there's the preparing of the report. Well, the new statute provides that a licensed engineer or architect must perform the visual inspection. And I thought it was interesting. Somebody brought up to me not too long ago, well, what is a visual inspection? I mean, I just figured you go out to the property and you do a survey, you look at it, and you make notes and findings. That would probably be the correct way to do it. But is that, doing it with a drone or looking at photographs? That's interesting, and that's yet to be determined because this is just brand new. And as we'll get to, the initial report is not due till the end of 2024. So we have some time to deal with this. But I'm not so sure I see this going away. You might need to start looking for engineer and architects or reputable reserve companies who have those people on staff to deal with this. Because what I have heard and what I do believe is true are there may not be enough reputable people to perform these studies. Specifically now that we have Ian and all the damage that has been done and all the rebuilding, your engineers and architects here in Florida are stretched thin. Are we going to see engineer and architects out of Tennessee and Texas and other states coming in and trying to quickly obtain licensure here in Florida to be able to do these reports? I wouldn't be shocked if we do. So that's component number one, the visual inspection. But then, interestingly, preparing the report can be prepared by anyone qualified to prepare the report. So this could be a two-step process where your engineer guy or girl goes out to the property, surveys, and then passes by notes to the reserve person in the office who runs the numbers. That's what those people do. They have reputable reserve study companies who analyze these things and come up with calculations, and they have algorithms, and they have cost analysis from all over the country to determine, how much products are going to cost now, and what the costs of all of these things are. So there's a two-part component: visual inspection and preparing the report. What I don't recommend is that you have your board prepare this report. You have your engineer go out there and give you some documents and some photos, and then somebody on your board runs the numbers. That's probably not what you want to do, because how do you know if you're qualified to be preparing this report? This report is specifically required by the statute. It's very detailed. And what are the components that we're looking at? That would probably be helpful to mention before we start in with me cautioning you, right? At a minimum, the statute provides that at a minimum, the following components of the building, 3 stories or more, must be part of this report. Interestingly, I'm just going to read them because it's a lot easier to do so, and I think it's actually important to hear what specific components are at issue here. Roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, which has given a lot of people pause, and any other item that has a deferred maintenance expense or replacement cost that exceeds that $10,000 mark, and the failure to replace that item negatively affects the items in A through I. So these are a lot of components that must be inspected and analyzed to determine what their costs are on a looking forward basis. What we have heard, and what I do agree with, is it's difficult to determine estimated remaining useful life of certain of these components. It's difficult to determine, what the lifespan is of a floor or as a foundation. Some of these are very difficult to look to because they don't have a reasonably predictable expected life. Your floor, we're just speaking generally right now, your floor should last a lifetime. Your foundation presumably should last a lifetime. So a lot of the reserve advisor companies, very reputable, are having a very difficult time with these items because historically they have not included some of these in their traditional reserve reports, because under their standards that govern their reserve reports, they're the National Reserve Study Standards, these reserve people use to prepare reports, have a test to determine whether an item is actually an appropriate reserve item. And some of these, the reserve advisors frankly tell us that they don't find to be appropriate to have a reserve because they don't have an estimated life. And we'll see how this plays out, whether the statute will be amended to remove some of these. I've said already, you might have already heard me say this, maybe we'll see these reports just highly qualified. I mean, a lot of reports are qualified where they'll have an asterisk by some of these components, and they'll say, it doesn't have, we cannot provide for this analysis due to the not, unreasonable predictability of the lifespan of the component. So we will see how that plays out. Window issue. People are, hopping up and down about this window issue. Well, owners maintain the windows. Why are we having to reserve for windows? And I think that's a good comment, right? Because in a lot of condominiums, your owners maintain the windows, and why should the association be reserving for something it doesn't necessarily maintain? But if you go back to the definition of the reserve study, it talks about a visual inspection of the common area. Common area isn't even a term that's defined in the Florida Condominium Act. We use common element. So I'm going to equate the two as the same and read everything together here, meaning that I believe, my opinion at least, is that it would be common element windows, whether they're common element windows that are serving the unit, or whether they're just the common element windows maybe in the lobby. I think that's the appropriate way to handle this, and not that you have to reserve or have a report related to windows that are not, maintained by the association, or that happen to be part of somebody's unit. They're within the unit boundaries. So that's a specific type of issue you have to look to. Each association is different. Windows are different in each condominium. Sometimes they're part of the unit, sometimes they're common elements, sometimes they're limited common elements. So that's when you kind of have to dig deeper and probably talk to your lawyer about, possibly, to get to the bottom of that issue. So when is this thing due? I did already mention that for unit owner controlled associations, the initial study is due by December 31, 2024. And whether that date is moved, extended, we will see how that turns out. And I believe that the intent of the statute is for everyone to obtain this study, every 10 years thereafter. So 10 years is quite a long time to wait to update your study. Typically, if you've had reserve studies, because you're a responsible association, you've had them every 3 years. You might not have your reserve advisor come out to the property every 3 years, but you'll have some kind of update, and you'll probably have them come out to the property every 5 years or fewer than that. So this 10 years is interesting to me because I feel like it's a really long time to have another study performed. Maybe that gets changed and gets reduced. We'll provide maybe some more clarification there. Once again, we'll get to see what will happen with that until some of this stuff plays out. For associations that haven't been turned over to the unit owners, have not transitioned, this structural integrity reserve study is also due at turnover, transition of control. So effective May 26, 2022, developers have been having to deal with this. If you had a condo that was supposed to turn over in July of 2022 or later this year, the developer has to provide you with this reserve study. There is no option for the developer to point to this December 31, 2024 deadline. They have to do it earlier. So what happens if you fail to obtain the study? If you fail to obtain the study, it's pretty serious, actually. It was written into the statute when this became effective that if an association fails to complete the reserve study, such failure is a breach of an officer and director's fiduciary relationship to the unit owner. So it's an automatic breach of fiduciary duty if you fail to complete this study. That's why, going back to my comment about the lack of reputable engineers and architects, you better get on this soon, because you can try to predict that maybe the deadline will be extended, but maybe it won't, and if it's not, and you're behind the 8 ball now, you're going to have to be scrambling to comply, or else you're going to be automatically breaching your fiduciary duty, which is something that you don't want to have to deal with. And you better have directors and officers insurance, if no matter what, but in this regard as well. So you don't want to wait till the last minute, because then you might have to go to a company that's frankly not reputable, which is not really the point of this. You want to know what the true costs are. Otherwise, the division is empowered to enforce compliance with the procedural completion of the structural integrity reserve study. So an owner can go to the division and make a complaint that your association did not obtain the study. The division is now authorized to investigate that and enforce penalties for these against the association should it be found to have not complied. Well, we talked about the reserve study, the new requirement, but how do you fund and how do you calculate reserves? And I sort of talked about this related to some of those components that we were having a hard time with. They're based upon the estimated remaining useful life of the item and deferred maintenance or replacement cost, right? We're not always talking about replacement. So you're not going to be replacing your foundation. You're not going to be replacing your floor, but you will have deferred maintenance possibly because your records and your concrete restoration records or, documents that you have through your prior construction show that there is some maintenance cost associated with these components. So don't always think that the reserve is regarding replacement. It's actually regarding maintenance expenses and replacement costs as applicable. Some items don't get replaced, but they require deferred maintenance, expected deferred maintenance to keep them up to snuff. So typically you're going to have two separate types of reserves that you use here. You probably are familiar with this. You'll have your straight line reserve, a separate account for each component, which essentially requires more funding, or you'll have a pooled analysis of two or more of the required assets. A lot of associations like the pooled reserve analysis because then you can essentially use the money in the pool to cover any of the items in the pool. But you must ensure that you stay on track and that you don't use too much money because now you're short money and now you're special assessing. So you want to look to see what type of reserve funding you have, what kind of account you have, the straight line or the pooled. And if you want to go to the pooled, you do have to take a one-time vote of the membership to authorize the pooled analysis because under the law, your reserves are supposed to be restricted and not used for other purposes without the prior written consent of the unit owners. And to pool them, you're kind of using them for a different purpose because the money is covering all of the items. So we do recommend that one-time vote. I have at the bottom here, is pooling authorized for the Sears components? Well, there's some debate of whether the items required by that Sears study can be pooled. Can they be pooled with other non-Sears items, maybe your tennis court or some other amenity items that are not part of that? And we just don't know yet. We're waiting for the division to give us some guidance, some rules, some administrative code provisions regarding these new laws. My personal opinion is that you have your traditional reserve components and your Sears components, and sort of you could have two separate pools that don't cross over. And we'll continue to update you as we get more information on whatever the division's position is going forward. Here's the definition of the straight line funding versus the pooled funding. You can go back and look at that. Other reserves. What about, can we create other reserves that are not mentioned by the statute? This comes up pretty frequently. Can we have a contingency reserve? Can we have an insurance reserve? And I think the Florida Administrative Code does support this, that you can have these type of reserves, but just realize that the funding is not subject to the traditional requirements because there's no estimated remaining useful life or anticipated deferred maintenance or replacement cost associated with these sort of broad categories. So you can have restricted funds for additional, things, but the funding of it is per the board, whatever the board proposes whatever the board proposes for that type of issue, contingency, insurance deductible reserve. I mean, that's not so bad. Okay, now we're going to the board meeting. I think most of you know that at least 14 days before the budget meeting, the board must deliver to each unit owner, mail, hand deliver, email with the prior written consent of the member, a copy of the board's budget meeting notice, and a copy of the proposed budget. The proposed budget has to have, we talked about the annual operating expenses anticipated, and also the proposed budget furnished to the owners must contain the reserve schedule. And the reserve schedule that's provided to the owners with the budget meeting notice must reflect the fully funded contribution for the reserves for that budget year. You don't have to show your reserves fully funded at all times. Again, this is reflect the fully funded contribution for that budget year. You're also required to post your budget well, actually the statute says you must post a proposed budget on a website for condos 150 units or more. It has some wishy-washy language about the proposed budget to be considered at the annual meeting, which really doesn't make sense because we don't consider budget at an annual meeting. But I read this to mean that you have to post your proposed budget to be considered at your annual board budget meeting on your website. Not everyone is subject to this website requirement. It's for condos 150 units or more, but just to keep in mind, because even I forget about this website posting requirement quite often. So keep that in the back of your head when you're going to send out your budget meeting notice, which I suspect most people are gearing up to do, or maybe they've already done. I mentioned that this is no less than 14 days, and I don't think I said that it had to be posted on the property, but that is also a requirement, I believe. But just keep in mind that your bylaws can provide for a longer notice period. I have several clients where their bylaws require 30 days notice for a budget meeting. So this is something you don't want to be in a gotcha situation where you send it out and then you have that one unit owner say, well, Article Roman numeral 5, subsection 5.3 requires the budget to be provided at least 30 days, and we didn't get it 30 days, and now you have to do it again. So just look at that. Don't forget about that. The default that we all know is the 14 days, but sometimes it's longer. As of last year, this is important to mention, that budget must be adopted at least 14 days before the end of the fiscal year. You cannot wait till December 30th to have your budget meeting any longer. As of last year, you better deal with this in advance. This is to give people the notice that they need of the amount of potential increased assessments that they're going to have to pay so they can plan. That's my thinking of the purpose of the law, right? If you fail to do that, the prior year's budget is going to continue in effect until a new one is adopted, and the division can consider this a minor violation for purposes of enforcement. But a minor violation is no joke. I mean, you can get a violation of $2,500 for a minor violation. So please ensure that you're timely with the noticing and conduct and approval of your budget. Don't wait until the last minute, as you may have done in the past. Do this more in advance. There also is some case law out there basically implying that if you fail to properly budget and then you try to go collect assessments, the unit owner can use your failures as a defense to payment of assessments. So this is quite serious, to timely adopt the budget to prevent any of those type of defenses. Okay, what about waivers and reduction of reserves, use for non-intended purposes? There are new stipulations here that are not triggered yet, but this is something that you probably want to hear about for those people who might want to drop off the call. We're nearing lunchtime. I would recommend you at least sit through this next section to hear about the new anti-waiver reserve law that just went into effect. Traditionally, as we all probably know, you're required to budget for a fully funded reserve contribution for the year. You have to show the owners what that looks like in the budget, but a majority of a quorum of the association was able to vote to either totally waive reserves or to reduce reserves to some other level. If you are supposed to contribute $100,000 to reserves for the next year, but you only want to contribute 50,000, then you have to get a vote of the owners. That is not within the purview of the board. The board has to show the budget with a fully funded contribution, and the board may propose that the owners waive or reduce that. On the other hand, the board does not have to propose this to the owners. I have many associations where the board has proposed waivers, reductions year after year after year after year, and then you have a new board come in and they say, you know what, we need to be responsible and start putting reserves away because we have a lot of deferred maintenance that we need to do because nobody's done maintenance, and they don't give the owners the opportunity to either waive or reduce that contribution, and the owners go crazy and they say the board, has to give us the opportunity to waive or reduce reserves. Well, that is not the case. It is within the board's purview whether they want to propose that waiver or not. Okay, very, very important. And actually, we're on use for not intended purposes, but it's the same thing. I'm sorry about that. As of effective December 31, 2024, members of a unit owner controlled association may not determine to provide for no reserves or less reserves than required for items listed in paragraph 718, 112, 2G. And that is the paragraph that lists the components that must be in that special reserve study. So as of the budget for 2026, we'll talk about this, associations will not have the option to propose that waiver or reduction. There's been some debate about who this applies to. Does this only apply to condos 3 stories or buildings 3 stories or more? What budget year are we talking about? And we did have some clarification from the division at a seminar that I was recently participating in, where the division stated that they believe that this anti-waiver applies across the board and not only to buildings 3 stories or more. It was also their division's position at the time. Again, this is, not cemented in law, but the division's position is very important because they're the ones who enforce the financial regulations for condo associations, that they believe that this anti-waiver would really only be applicable for 2026 because they believe that you can still waive in 2024 for a budget in 2025. So there is room for this to be clarified. I'm working with my Florida Bar Committee to try to get some technical amendments to the statute to clarify, frankly, that the anti-waiver, as I call it, would only apply to buildings 3 stories or more, the buildings that were required to obtain the study. But that was the position of the division. So, with that said, if you are in an association who has historically waived your reserves every year, and you've put off a lot of your capital projects, once we get to 2026, your budget is going to go up, a crazy amount. So I don't recommend that you just anticipate these things are going to be changed or put off. So it would be responsible, in my opinion, for you to, if you historically waived year after year after year, to start now contributing to your reserves at least partially and not totally waiving, such that when you get to 2025, 2026, you're not in such a bad situation. Similarly, you probably want to enact special assessments now or through your budget to do some of the capital projects that you've put off, so your reserve contribution in these future years will not be so great. And I hear this all the time, well, will we need to have the reserves completely funded? We need to have cash on hand to do all of our projects in those later years? No, but you'll have to put away what the fully funded contribution is for that year so that you're on track to do the maintenance or replacement in the year for which it is required. So you're not putting, all of the money into the reserve day one unless you have like no years left on your roof. If you have 10 years left on, 5 years left on your roof, you're putting away 1/5 of that in year one until you get to year five. So don't be be concerned, but don't mistake that that you have to have fully funded reserves at all time. That's not what this law requires. That's never been required. That is not what this means. If you are going to do any waiver or use for not intended purposes, reduction of reserves, you can still do that now. And even for the associations that are subject to the new law, you can still waive or reduce for the components that are not required to be funded. So if you have a tennis court, if you're a condo 3 stories or more and you have a tennis court that doesn't affect the structure of your building, that's an opportunity still for a waiver. So you could have you could still waive the non-required items. If you do that, important that you have to include this big bold language in any proxy or ballot that you use for your vote. I just saw yesterday an association that proposed a proxy to waive reserves for the upcoming 2023 year, and it did not include this big bold language. This big bold language is required by the statute. If you don't include it, it could be a violation. An owner could call you on it. You'll have to get the vote again. It's just a pain in the neck. So just make sure you include this. It's right there in the statute. Copy and paste it from my PowerPoint here. It has to be in bold, and it has to be in a font larger than any other font on the page. So if your proxy is in size 12 font, this must be in size 14. Emergency powers. I thought it was important to mention for those who might still be under a state of emergency declared by the governor that we do have certain emergency powers we can use during that time and reasonably thereafter, right? That does not include using reserves for not intended purposes without the vote of the owners. We have associations where they've had destruction. They have to make insurance claims. They have high deductibles, but they want to use their reserves, their roof reserve, to pay their insurance deductible. Well, the emergency powers statute does not authorize that, and you have to go get the vote of the owners to use reserves for that not intended purpose. Maybe we'll see a change. I could see that, but at this time, that is not authorized by law. I thought it was important to mention, we're getting into some kind of like miscellaneous type stuff right now. Finance committee, if you have a finance committee and they make recommendations to the board regarding the association budget, the finance committee meetings must be noticed in the same manner as board meetings, and owners are allowed to attend and make statements. So don't trip up on that. It's kind of like buried there in the law. Other committees, actually for condominium associations, unless your bylaws exempt you from having noticed committee meetings, all committee meetings have to be noticed and open to the owners. But even if your bylaws exempt committee meetings from this requirement, these 2 special committees shown on this page, including the budget recommendation committee, always has to be noticed and open to owners. Special assessments, we do have a few slides here. I know we only have 10 minutes left. That's why I said we had a lot of material to cover. And I'll try to run through this really quickly, but I do really like this little cartoon. I'm not a cartoon person. What's a special assessment? I don't know, but special means it's good, right? No, it's not usually good. We don't like special assessments, but we have to have them. We have unanticipated expenses that come up through the year. We have capital items that just like we're not in the budget, we're not planned for reserves, so you will have to have a special assessment. You have that contingent special assessment levied in connection with an insurance policy, maybe. Sometimes governing documents require the approval of owners in order for the board to enact special assessments. I think those provisions are probably legitimate, but caveat, if you have necessary maintenance that you have to do or else your building is going to fall down, then I would probably give you the opinion that that owner approval is just not required. You have to consult with an attorney to evaluate this. It's very fact specific. But even with a limitation or restriction on an assessment, you can get around that in certain circumstances where you just have to replace something or do the work. Typically speaking, I'm going to tell you to go out and get a professional's opinion that that is necessary and that you actually do need it. So something to mention. Finally, because I know we have only a few minutes left, unlike use of reserves during an emergency where you cannot touch them, the emergency power statute does allow you to make special assessments and borrow money in connection with an emergency. And no matter what your documents say about special assessments or borrowing, if there's a restriction, then the emergency power statute allows you to get around that. But remember, emergency powers are only triggered when the governor declares an emergency. If your county declares an emergency, that's not good enough. It has to be by the state. We have some items about special assessment meetings and what they must, the notice of the meeting must include, and some other stipulations as to special assessments. But I know we're pretty much nearing the end of this, and I believe Jeff Solomon, our intro, who gave the intro, wants to say a few words. And there we are done. We had a lot of questions. I wish I could get to some of these questions, but there's just a lot of material to go over. I'm going to read these questions, and if you've seen me before, I do try to get back to some of y'all on some of these questions, and I can try to do that. If you want to email me, if you have a question, you can feel free to do that.